exam prep, and this is the last lab to CLAT 22, and we are going to study some major doctrines under the constitutional law. Good evening. Yes, these are important. They may come in straightforward passages in your exam, and the concept relating to these is pretty simple, and if you understand it, you have done a big chunk of your constitution, trust me. So straight without derivation questions can come when we talk about this topic. Yes, good evening, how are you? Good evening, guys. Good evening to everyone. How are you all? Hello, hi. I'm glad I could help you, Venkat. I'm really glad that I could. These sessions are to help you. They are only for you. They cover the topics that are most important that students often tend to miss. So yes, since they are devised keeping you in mind, they should be helpful, right? That's our goal. So the first is Doctrine of Eclipse. Let us wait for a few more moments and then we shall begin. No problem, anyone. Strategies all over. I'm always open to giving you the best strategies that I can. Some strategies that even I used while I was preparing for CLAT, because there was a time when I was also preparing for CLAT and I took 2 CLATs, not just one, UG and PG. क्या कॉन्स्टिट्यूशन का नॉलेज होना जरूरी है क्लैट में? देखिए अविनाश, कॉन्स्टिट्यूशन जो है ना वो आपका लॉ ऑफ द लैंड है. मतलब इस देश में जितना भी लॉ बनाया जाता है या बन चुका है वो सब ऐसे बनाया जाता है कि भाई कॉन्स्टिट्यूशन वायलेट ना हो जाए, कॉन्स्टिट्यूशन में लिखी हुई बात कोई बुरा ना मान जाए. तो कॉन्स्टिट्यूशन इस देश का कानून है, उसी से बाकी सारे कानून निकल कर आ रहे हैं. तो आप अगर लॉ में थोड़ा सा भी इंटरेस्ट रखते हैं तो कॉन्स्टिट्यूशन के बारे में आपका पता होना इम्पेरेटिव है. I'm good too. Thank you so much. Okay, so let us start the Doctrine of Eclipse. Now, the Doctrine of Eclipse is very simple. Everybody knows what an eclipse is, right? When the galactic bodies cover each other in such a way that we are unable to see other body. Right? Who is this guy talking to? Who are you talking to? Please don't talk like that in my class. Be civil. At least try. Right? I know it is hard for some people, but can you try? Yeah. So Doctrine of Eclipse. What is eclipse? So eclipse is a natural phenomenon in which galactic bodies cover each other. Like not one of the galactic bodies cover one, and the other one is invisible. So for example, there is an eclipse, lunar eclipse, in which the moon is in front of the sun, right? The placement is such that because of that revolution that we are not able to see sun for few minutes, right? That is what an eclipse is. Lunar eclipse, solar eclipse, all that. Now eclipse is when you are not able to see something. In simple words, eclipse is when something is covered in such a way that it is not visible anymore, right? Now when we talk about constitution, think about that. Think about the fact that constitution is something that we did not always have. We got constitution after we attained independence, which was in 1950. It was in 1950 when we got our constitution enforced, given to the people of India, right? Before that, we had laws. Of course, we had IPC, Indian Penal Code, which was given to us in 1870s. We had Contract Act, we have Transfer of Property Act, we had criminal procedure, civil procedure. We had laws relating to every concept, civil or criminal. What we did not have was from where will you get Jamia latest mocks? From BYJU'S portal you can get Jamia's latest mocks. Right. So what we did not have was independence. We did not have independence. We were not independent. So whatever laws British gave to us were being followed by us. After we became independent, there was a requirement of a certain law that would govern the entire country, an independent, a newly independent democratic republic. For that, we needed a new law which would guide every government that is going to rule this country or every government that is going to be in power, right? Now, when the constitution was devised, we already had a lot of laws existing. And there were certain provisions in those laws which did not really complement the current scheme of constitution. Now, our country was a democratic republic. We were independent, we were sovereign, we were what not? We were the rulers of the world, not really. But yes, we were like pretty ambitious, and the constitution framers wanted to give their citizens everything that they never had before. And the laws that were given to us by British were something that were devised according to their convenience. जो laws British ने बनाए वो अपने लिए बनाए, अपनी convenience के लिए बनाए. तो उनमें बहुत सारे ऐसे provisions थे जो constitution की नई scheme में fit नहीं होते थे. Right? For example, the doctrine of equality that our constitution provides as a fundamental right, or the basic freedom of practicing religion, Article 21, Article 14, Article 25, the concept of secularism, the concept of sovereignty, the concept of republic, the concept of democracy, a lot of concepts like these, which were very, very new, but they were not recognized because we were ruled by a colonial power, right? But the cases relating these laws were already in motion. They were already pending. As you know, that a disposal of a case requires a long time frame. So many cases were pending which were already dealing with the provisions that the constitution did not really approve, right? Now what happened was the doctrine of eclipse was devised. It is given in Article 13, but it is not given expressly, like we have named it. So Article 13 says that if there is a law that has been enforced after the constitution came into force, which is after 1950, and that law in any manner, if it violates the provisions of constitution, it will be void. That is, it will not apply to the people. अगर कोई एक ऐसा लॉ है जो 1950 के बाद आया है, कॉन्स्टिट्यूशन के बनने के बाद आया है, राइट, और वो कॉन्स्टिट्यूशनल स्कीम में फिट नहीं हो रहा, कॉन्स्टिट्यूशन के प्रोविजंस को पूरी तरह से केटर नहीं कर रहा, उसकी स्कीम को वायलेट कर रहा है, बेसिक स्ट्रक्चर को वायलेट कर रहा है या फंडामेंटल राइट्स को वायलेट कर रहा है, तो वो लॉ इमीडिएटली वॉइड होगा. किस तरह से? वो लोगों तक पहुंचने ही नहीं दिया जाएगा, उसे अप्लाई ही नहीं किया जाएगा. So a law which is enforced after 1950 and is violating constitutional provisions will not work, will not be executed, it will not be given to the people. Okay, it won't apply on people. It is void since the date of inception. This is post-constitutional laws. What is the status of pre-constitutional laws? Now we know that whatever comes after the constitution obviously will have to complement the constitution, which will have to make sure that it is following the constitution, right? But what about the laws that were created before the constitution? What about them? Obviously, they were not devised keeping the constitution of India in mind because it was not existing back then. What about those laws? So those laws are covered. The laws that came before 1950 are called pre-constitutional laws. And believe me, most of the laws, most of the substantive procedural laws that we have are pre-constitutional. The major laws, the core laws, IPC, CRPC, CPC, Transfer of Property Act, Indian Contract Act, all of these are pre-constitutional. So what if they contain something which is not really abiding by the schemes of the constitution? ठीक है, अगर कोई ऐसा लॉ है जो कॉन्स्टिट्यूशन पे खरा नहीं उतर रहा, कॉन्स्टिट्यूशन को पूरी तरह से फॉलो नहीं कर रहा और वो कॉन्स्टिट्यूशन के बनने से पहले बन चुका, तो अब उसका क्या होगा, उसको एक्लिप्स कर दिया जाता है. इन अदर वर्ड्स, इट इज एक्चुअली कवर्ड. It is covered in a sense that the judiciary does not use it. The executive does not execute it. The law is there in the bare act, in the bare provisions, it would be there, but it will not be used. So it is as if the law is not even there, but it will work for those cases which are pending before the constitution was enforced. तो वो केसेस जो 1950 से पहले के हैं, अगर वो चल रहे हैं, वो आज भी पेंडिंग है, और वो किसी ऐसे लॉ को कवर करते हैं जो प्री कॉन्स्टिट्यूशनल है, तो हम उस प्री कॉन्स्टिट्यूशनल लॉ को, भले ही वो वायलेट कर रहा है कॉन्स्टिट्यूशन को, यूज कर लेंगे. लेकिन 1950 के बाद कोई भी अगर एक्ट होता है तो उस लॉ को यूज नहीं किया जाएगा, उसे ढक दिया जाएगा, उसे एक्लिप्स कर दिया जाएगा. That is what doctrine of eclipse is. Did everybody understand? Anybody, any doubt whatsoever? Got it? So people who don't understand Hindi, I'll revise it. So whatever law that we have, if it came before the constitution and if it contains a provision that is not abiding by the constitution, or it is violating the constitutional provisions or the scheme of the constitution, then instead of removing it altogether, we keep it, but we eclipse it, we cover it, and we use it only for the cases and for the instances that happened before the constitution was enacted. Okay, now you'll ask me, ma'am, the cases before 1950, are they still pending in 22? You'll be surprised to know that they are. Some of them are. Okay. So this is the doctrine of eclipse. The doctrine of eclipse means that an existing law that is inconsistent with a fundamental right, even if it becomes inoperative from the date of Constitution's enactment, is not entirely dead. It is used for the cases and the instances that happened before Constitution, but it will be deemed dead for the cases that happen after 1950, that is the enforcement of Constitution. Right? So in contrast, pure post-constitutional laws that infringe fundamental rights are null and void from their inception. And the case relating to this doctrine was BYJU'S versus State of MP, where a pre-constitutional law was applied, and it applied because the case relating to the instance relating to the case was before the constitution came into force. Manish, it is on the same YouTube channel, buddy. It is on the same YouTube channel. Now, the extension to the post-constitutional law was stated in the case of Dulari Lodh versus ADJ Kanpur. These are the cases you can read if you want, but not as important. Now we have doctrine of territorial nexus. Territorial, you know what territory is. Territory is the geographical area, and nexus is the relationship, right? So territorial nexus is the geographical relationship between laws. Are you getting my point? Now, what exactly is territorial nexus? Think about the fact that, not think, you know it. Article 13 judicial review होता है. अच्छा, आर्टिकल 13 से ही जुडिशियल रिव्यू की पावर निकल कर आती है. आर्टिकल 13 कहता है कि अगर फंडामेंटल राइट्स को कोई चीज फॉलो नहीं कर रही है तो वो नल एंड वॉइड है. अब वो फॉलो नहीं कर रही है, नल एंड वॉइड है, ये पता लगाने का काम जुडिशरी का है. तो आर्टिकल 13 प्रोवाइड करता है जुडिशरी को जुडिशियल रिव्यू की पावर के साथ. कहीं लिखा हुआ नहीं है उसमें. सिमिलरली आर्टिकल 13 में डॉक्ट्रिन ऑफ एक्लिप्स भी नहीं लिखी हुई है, उसे डिवाइस किया गया है. ठीक है, राइट. हिंदी और इंग्लिश दोनों बोल रही हूँ खलनायक, क्या बात है. ओके, नाउ अब ऐसा है कि हमारे पास जो गवर्नमेंट है उसका रेस्पेक्टिव पावर डिवाइडेड है. The power of the government is divided between their respective territories. For example, the state of Uttar Pradesh or the government of Uttar Pradesh can govern the state of Uttar Pradesh only. जो यूपी की सरकार है, योगी आदित्यनाथ की जो सरकार है, वो जो भी करती है, कोई लॉ बनाती है, एग्जीक्यूट करती है, कोई रूल लेकर आती है, कोई पॉलिसी लेकर आती है, कोई स्कीम लेकर आती है, कुछ भी करती है वो सरकार, तो वो किसके लिए कर रही है? उन लोगों के लिए जो यूपी में रह रहे हैं। योगी आदित्यनाथ की सरकार कुछ भी ऐसा नहीं कर सकती जो दिल्ली के लोगों पर अप्लाई करे, क्योंकि दिल्ली के लोगों के लिए उनकी अपनी गवर्नमेंट है, राइट। इसी को टेरिटोरियल नेक्सस या टेरिटोरियल रिलेशनशिप कहा जाता है। हर एक स्टेट लेजिस्लेशन के पास पावर है कि वो अपनी स्टेट के लिए लॉ बना सके, right? Central legislation, which is the parliament of the country, has the power to make laws for the entire country, but the state legislature can only make laws for their own state, and the application of that law cannot extend the boundary of that state. UP government cannot make any law which is applying on anybody else other than the citizens of Uttar Pradesh, and if it does, the doctrine immediately comes into picture. Federalism is something, yes, you can say federalism is more like division of power on a greater level. For example, what center can do and what state can do, right? Now imagine that there is a law that the government of UP makes, right? Let's take a hypothesis. Let's say that UP government comes up with a law which says that if there is a vehicle which is carrying a load of more than 300 tons would have to pay additional freight charges if they are traveling or if they are moving. Okay, so any vehicle, any commercial vehicle moving or traveling with a weight of over 300 ton would have to pay an additional freight or an additional tax if it is registered under the state of UP, or if it is registered with the state of UP, with the RT, what is that entity that governs the driving and everything, if it is registered in the state of UP. Let's just keep it to that. Okay. Now, Madhya Pradesh also makes that laws. Madhya Pradesh makes a law that any vehicle moving in the state of Madhya Pradesh, okay, any vehicle that is in the state of Madhya Pradesh, and if it is carrying a weight of more than 300 tons would have to pay an additional tax. Now, let's say that there is a truck, RTO, yeah, RTO. I was slightly confused. So, let's say that a truck registered with the state of Uttar Pradesh enters Madhya Pradesh. Now it is already carrying more than 300 tons, and since it is carrying more than 300 tons and registered with the RTO of UP, it has already paid the additional tax. Now this truck enters Madhya Pradesh. Okay, this truck enters Madhya Pradesh and the law of Madhya Pradesh applies on the truck of UP, and the truck of UP says that I do not belong to your state, I do not live in your state, I am just transporting material, I am not bound by your law, I have already paid an additional tax in my state, I don't have to pay anything in your state. फिर से समझ लो, लेट्स से कि यूपी एक लॉ लेकर आती है जहां पे ये कहा गया है कि अगर 300 टन से ज्यादा कोई भी वेट एक व्हीकल, कमर्शियल व्हीकल कैरी कर रहा है तो आपको एडिशनल टैक्स देना पड़ेगा, ठीक है, अगर वो ट्रक या फिर वो व्हीकल यूपी आरटीओ से रजिस्टर्ड है। एमपी का भी इस तरह का एक लॉ है जहां वो कहते हैं कि कोई भी व्हीकल जो कि 300 टन से ओवरवेट है उसे एमपी में टैक्स देना पड़ेगा, राइट। अब यूपी का लॉ थोड़ा स्पेसिफिक है, वो सिर्फ यूपी के लोगों पर लग रहा है। अब यही यूपी के रजिस्टर्ड एक व्हीकल मध्य प्रदेश जाता है और वो यूपी में माइंड यू ऑलरेडी टैक्स दे चुका है, 300 टन से ओवर है, यूपी में टैक्स दे चुका है। अब वो जाता है मध्य प्रदेश में और वहां पे भी उस पर टैक्स लगा दिया जाता है। अब ये ट्रक वाला कहेगा मैं तो तुम्हारी स्टेट का नहीं हूं और मैं अपनी स्टेट में ऑलरेडी टैक्स दे आया तो तुम्हारी स्टेट में क्यों दूं, ठीक है। अब यहाँ पे टेरिटोरियल नेक्सस के हिसाब से अकॉर्डिंग टू द डॉक्ट्रिन ऑफ टेरिटोरियल नेक्सस द लॉज ऑफ एमपी कैन ओनली अप्लाई टू द सिटीजंस ऑफ एमपी, इट कैन नॉट अप्लाई टू एनीबडी एल्स आउटसाइड मध्य प्रदेश। नाउ द डॉक्ट्रिन interferes and says that the relationship between the area is seen is the law of the state devised keeping in mind the other people also, or it is only devised for its own area. Now the MP law is not enforced to collect taxes from people belonging to other states, no. It is devised so that any overload vehicle, if moving on their roads, can pay for the damage or for the wear and tear that happens to the roads. इतना भारी व्हीकल अगर सड़क पे चलेगा तो सड़क का wear and tear होगा, वो डिस्ट्रॉय होगी, उसका जो वैल्यू है वो डिमिनिश हो जाएगी, उसकी कंडीशन थोड़ी सी कम हो जाएगी. अब उस कंडीशन को मेंटेन रखने के लिए पैसा चाहिए. अब वो पैसा उसी से खरीद लिया जाए जो कि उसकी उस डिटीरियोरेटिंग कंडीशन के लिए रिस्पॉन्सिबल है. तो ये लॉ इसलिए नहीं बनाया गया ताकि तुम दुनिया के हर इंसान से टैक्स कलेक्ट कर सको, नहीं, ये इसीलिए बनाया गया ताकि तुम अपनी स्टेट के इंफ्रास्ट्रक्चर को मेंटेन कर सको. तो लॉ का जो रिलेशनशिप है वो सिर्फ और सिर्फ उसी एरिया से और उसी टेरिटरी से है. ठीक है, जो मध्य प्रदेश का लॉ है उसका रिलेशनशिप अपने स्टेट से ही है और ये रिलेशनशिप किसी और स्टेट तक नहीं एक्सटेंड हो रहा. इसीलिए इस लॉ को वॉइड डिक्लेयर नहीं कहा जाएगा. What I do not understand. Yes. Are you guys clear? Do you understand? So whenever doctrine of territorial nexus interferes, it means that there is a law whose interpretation seems to be exceeding the boundary of that state. So to determine what is the territorial connection of that law with the other state and with the home state, this doctrine is taken into picture. If the relationship or the incorporation is such that it is only related to that particular state only, if there is an application to anybody else, it is coincidental, it is only accidental, it is not meant to apply on anybody else, it is solely for that state only. Got it? So this is what the doctrine of territorial nexus is. It is given under Article 245 and 240, obviously just 245. 245 provides that Parliament of India can make laws for the whole or the entire territory. Similarly, state legislation can make a law for its own state, right? Such laws can be declared invalid on the ground that they are extraterritorial according to 245 clause 2. To determine whether a particular legislation is within territorial nexus or not, this doctrine is applied. Article learn nahi karne hain. Okay. So like I told you, this doctrine is applied when it is to be examined whether a particular legislation has a territorial nexus or not. No, you don't need to remember any article. You don't need to remember any article. Now we have doctrine of colorable legislation. Based on the doctrines, they definitely can ask the questions. In fact, these doctrines can be straight away asked in the exam. That is why we are giving this material to you. They can straight away be asked in the passage, right? And then there might be a factual situation relating to what. Just yep. Then there might be a factual situation related to the doctrine, and then they would ask you, would the doctrine apply? Anything happen, just be prepared for anything, right? Now, doctrine of colorable legislation. Think about the fact that let's say there is a ruling party A, right? There's a ruling party. How does a party become a ruling party? When does a party become a party at the center? When it is able to win the maximum seats. Right? When it is able to secure the maximum constituencies, we call that party a ruling party. So in order to do that, they have to secure at least more than 50% of the constituent seats. Right? तो 50% से जैसे ही सीट्स उनके पास आ जाती हैं ऊपर, वो रूलिंग पार्टी हो जाते हैं, वो सेंटर में जीत जाते हैं और उनका लीडर जो है वो प्राइम मिनिस्टर बन जाता है. ये इंडिया का सिस्टम है. अब ऐसे समझो कि let's say there is a ruling party which has able to secure its constituency in A, B, C, D, 4 states, and total there are 6 states. In 2 they are not able to secure the winning vote. They're not able to establish their government in 2 states out of 6, but they have won in the other 4. Now, since they have won by majority, they will be able to establish the central government. Now, sometimes what happens, actually it does not sometimes happen, it happens all the time. Yes, Amit, you only have to learn the concept, nothing else, right? So what happens is that there is a tier of government, everybody knows it. Central government has a certain power, state government has a certain power. Central government can create laws for the entire country, state law can create laws only for their own state, right? But there is a division of list also. It is not that central government can do anything. No, it is not like that. Central government can only legislate on the subjects given to it under the list. Right? There's a certain list in the 7th schedule which gives out certain subjects. So there are 3 lists: list 1 union, list 2 state, and list 3 is concurrent. Now, whatever law, whatever subject is given in the state central list and the concurrent list are the subjects on which center can make laws upon. When a subject is from a state list, center cannot create laws on it. Only a state legislation can create a law on it. Now, let's say that center wants to create a certain legislation which is relating to a subject given in the state list, but it cannot do so. And it can create laws for the entire territory, but it cannot create state specific laws. वो उस सब्जेक्ट को टच नहीं कर सकते जो कि स्टेट लिस्ट में दे रखा है, लेकिन वो बनाना चाहते हैं उसके ऊपर कोई लॉ, और वो बना सकते नहीं है. क्यों? क्योंकि भाई स्टेट में उनकी गवर्नमेंट नहीं है. आउट ऑफ 6 सिर्फ 4 स्टेट्स हैं जिनमें उनकी गवर्नमेंट है, तो उन चारों में तो वो बना देंगे स्टेट लिस्ट का कोई लॉ, लेकिन बाकी 2 में नहीं बना पाएंगे. तो ये लोग क्या करते हैं लोग, ये ले आते हैं प्रेसिडेंट्स रूल. क्योंकि गवर्नर जो होता है वो प्रेसिडेंट का रिप्रेजेंटेटिव होता है state में, right? Governor is the representative of the center in the state. So as soon as the governor declares that there is a failure of constitutional machinery, which means the state government is not functioning according to the provisions of the constitution, immediately the president interferes. The state government is suspended, it is not functional anymore, and the central government takes charge on the state government. So even without winning the voting system, winning the election, even without winning the election, they are able to govern the states by using or misusing rather the power given in the president's rule. समझे? अब क्योंकि उस स्टेट में उनकी सरकार नहीं है और उनको उस स्टेट में भी सरकार तो चाहिए, तो क्या करेंगे, गवर्नर से कहेंगे कि जरा पेपर साइन करो और कहो कि ये स्टेट गवर्नमेंट ठीक से काम नहीं कर रही. जैसे ही गवर्नर उस पेपर को साइन करेगा, स्टेट गवर्नमेंट तुरंत ही डिसमेंटल हो जाएगी. जैसे ही स्टेट गवर्नमेंट डिसमेंटल हो जाएगी, स्टेट बिना सरकार के तो रह नहीं सकती. सेंट्रल गवर्नमेंट शक्तिमान की तरह आएगी और उसका पूरा दारोमदार उठा लेगी. तो इलेक्शन जीते बिना भी ये लोग अपना आधिपत्य हर स्टेट में जमा लेते हैं. हर सरकार, हर रूलिंग पार्टी जो कि सेंटर में है लेकिन कुछ स्टेट्स में उनको मेजोरिटी नहीं मिली, वो इसी पावर को मिसयूज करके अपना काम इधर उधर करते रहते हैं. ठीक है, ये जो तरीका है ये तरीका गलत है. आपको अगर कहीं पे भी गवर्नेंस एस्टैब्लिश करना है तो आपको इलेक्शन जीतना पड़ेगा. अगर आपने इलेक्शन नहीं जीता है तो आप उस स्टेट को गवर्न भी नहीं कर सकते, आप गवर्नमेंट का हिस्सा नहीं बन सकते. ये कॉन्स्टिट्यूशन कहता है. लेकिन वहीं पे कॉन्स्टिट्यूशन एक लूप होल भी दे देता है प्रेसिडेंट्स रूल के नाम का. तो यहाँ पे वो सेंट्रल गवर्नमेंट जो डायरेक्टली नहीं कर सकती वो इनडायरेक्टली करती है. जहां वो डायरेक्टली रूल नहीं कर सकते वहीं पे वो लूप होल को इस्तेमाल करके इनडायरेक्टली रूल करना शुरू कर देते हैं. और इसी डॉक्ट्रिन को कलरेबल लेजिस्लेशन कहा जा सकता है. हर जगह होता है आकांक्षा, इट हैपेंस एवरीवेयर. Okay, it happens everywhere. So if there is something that the Constitution does not allow. Got it? If there is something that the Constitution is not allowing, but you still want to do it, you want to override the Constitution. So you begin finding loopholes. And if you're able to find loophole, you use that loophole and do something which you are not directly allowed. And when you do that, this is called doctrine of colorable legislation. When you do something indirectly, what you cannot do directly. When you travel to a country, you're not bound to follow the rules of that country. No, who told you that? You're supposed to stay within limits, right? There are certain laws that are applicable only to the citizens of the state. So it's not that, ऐसा नहीं कि अब तुम दूसरी कंट्री में जाते हो तो तुम पर सारे कानून लगेंगे, तुम्हें दूसरी कंट्री में जाके टैक्स देना पड़ता है क्या? नहीं. अब लेट्स से कि स्विट्जरलैंड में गार्बेज टैक्स है, ठीक है, और तुम स्विट्जरलैंड में कुछ टाइम के लिए वेकेशन मनाने चले जाते हो, क्या तुम्हें गार्बेज टैक्स देना पड़ेगा? नहीं देना पड़ेगा. ठीक है. लॉ एंड ऑर्डर से रिलेटेड जो लॉज होते हैं, रूल्स एंड रेगुलेशंस होते हैं, पब्लिक ऑर्डर से रिलेटेड, वो हर किसी पर लगते हैं जो उस कंट्री में है ताकि पब्लिक ऑर्डर मेंटेन हो सके. करेक्ट. ताकि पब्लिक ऑर्डर मेंटेन हो सके. तो ऐसा नहीं होता. Yes, it is Article 356. Now, the doctrine applies when the legislature does something that cannot be done directly within its scope of power. It is based upon the doctrine of power of separation. The doctrine of separation of power mandates striking a balance of power between different state components. इसको एक ऐसे भी समझ सकते हैं. Let's say that there is a topic or a subject irrigation given in the central list, right? And there is a topic or there is a subject. I'm giving you an example. Latest example, you can go scrounge the internet, do some research yourself. ठीक है, आप खुद भी थोड़ा सा रिसर्च करिए. मैं आपको एग्जांपल दे रही हूँ. Let's say that there is a subject irrigation in the central list. Okay, irrigation is absolutely something else. And then there is a subject related to seeds. Okay, or everything that facilitates agriculture. For example, seeds, fertilizers, pesticides, technology, whatever it is that makes the agriculture easy. The topics related to that are given in the state list. Now, what center does is they make an indirect law on seeds to facilitate irrigation. And then they say that we are not making a law on the seeds, we are only making a law on irrigation. Seeds are inherent part of irrigation. तुम्हें मेरी बात समझ आई? अब वो लोग सीड पे डायरेक्ट लॉ नहीं बना सकते थे क्योंकि बीज जो है वो स्टेट लिस्ट का हिस्सा है, लेकिन इरिगेशन है उनके पास, तो उन्होंने इरिगेशन से जुड़ी हुई एक बहुत ही क्रूशियल चीज को उस पे उन्होंने लॉ बना दिया और कह दिया ये तो इरिगेशन का हिस्सा है, इस पे तो लॉ हम बना सकते हैं क्योंकि हम इरिगेशन पे लॉ बना सकते हैं. और इरिगेशन में सीड्स बहुत इनहेरेंट होते हैं. तो अब यहाँ पे जो वो सीधे सीधे नहीं कर सकते थे उन्होंने इनडायरेक्टली कर दिया. दिस इज कॉल्ड डॉक्ट्रिन ऑफ कलरेबल लेजिस्लेशन. गॉट इट एवरीबडी? एनी डाउट व्हाटसोएवर? So it is based on the maxim that what cannot be done directly also cannot be done indirectly. जो चीज आप सीधे सीधे नहीं कर सकते उसे आप indirectly भी नहीं करेंगे. It is applied when the legislature does not have a right to make a law for a particular subject but indirectly makes one. Right? So the court has laid down certain tests for discovering whether any particular act constitutes colorable legislation. सबसे पहले तो the court does not have to look on the label or what is written on as a title. It has to see what is the substance of that law. What does that law actually regulates? If that law regulates what is written on the title or on the first page, then it is okay. But if the title is something else, but the substance of the law is interfering with state's power, is interfering with the state list, then the doctrine of colorable legislation will strike and this law will be removed. Got it? The court must look at the object as well as the effect of the law. Why is the law even enacted and what is that effect of the law? If the object and the effect is to regulate a particular subject of the state list, then the substance or the significance of the law is interfering with the federal structure. The law cannot apply. Got it? See, if the legislature proceeds under a legislative plan, then the court must read all the statutes constituting the plan and determine the combined effect. If there is a legislature which is a part of certain sequence, is a part of certain sequence, like multiple laws का एक part है, तो सारे laws का इकट्ठा effect देखो, निकाल के देखो, क्या वो ऐसा effect है जो कि तुम ला नहीं सकते थे, जिसको लाने की power तुम्हें constitution ने नहीं दी रखी? अगर ऐसा है तो फिर सारे ही laws को हटा दिया जाएगा, right? So that's it for today guys. आज के लिए इतना ही. Doctrine of Colourable Legislation एक और doctrine है which you would do as your homework. It is called the Doctrine of Pith and Substance. इसे आप homework में करेंगे, अच्छे से पढ़ेंगे. It is an important doctrine. If you're not able to understand it, you may very well post it in the doubt portal. I will be very glad to clarify it. And everybody, that's it. Everybody like the session. Nobody is supposed to leave without liking the session. And I shall see you again very soon. Tulika, I'm afraid that won't be possible. Shiv, 15-20 days. 15-20 days में से पहले आ जाता है. Okay. So thank you guys. Thank you so much. You can take the screenshot of everything and that can be your notes. Everybody, good night. Take care. Do like the session. Share the session, comment on it and subscribe to our channel if you haven't already. And we shall meet with each other very soon. Bye. Yes. Take care guys. Thank you.